Hello everyone, this is Ghost Hunter Joe. As the viewer will see, today's story is rather personal for me, as it takes place at the Ohio State Reformatory, where I started my career with the Ohio Department of Rehabilitation and Corrections from 1984 to 2009 as a correction officer, correction sergeant, correction lieutenant, and acting correction captain. I worked at this 19th century maximum security prison as a correction officer from 1984 until it closed under court order in 1990. Prior to my employment at the Reformatory from 1978 to 1982, I worked in the security and law enforcement fields while attending the Ohio State University, where I received my associate degree in criminal justice and my bachelor's degree in criminology. I am also a 1984 graduate of the North Central Technical College Police Academy. While working at the Reformatory, I enlisted in the United States Army Reserve and attended and graduated from the United States Army Military Police School. My service to country after my initial basic training and military police training at Fort McClellan, Alabama, included attending monthly drills and 2 weeks of active duty training each summer. In case the viewer didn't know, at least during the 6.5 years I worked there before it closed, the Reformatory was extremely anti-employee and anti-union. They were so anti-employee that they pushed me from being a person who swore he would never join a union into a union activist and organizer. I would eventually become an award-winning founder and editor of the union's newsletter, as well as successful union steward, lead steward, chief steward, and eventually union president. I am proud to say that I won over $1 million in back pay from my fellow co-workers who were either wrongfully fired or over-disciplined. But winning doesn't come easy. As a direct result of my success, I was retaliated against and written up over 400 times. As it turns out, the Richland County Prosecutor's Office was also extremely anti-union. In collusion with the Reformatory, they maliciously and wrongfully prosecuted innocent union representatives, including Mark, Mike, Donnie Joe, John, Jerry, Bob, Hank, Doug, and me. In addition to writing me up over 400 times, the Reformatory retaliated against me in other ways, including messing with my paychecks. There was a period of almost a year when my pay was wrong every single pay period, and incidentally never to my advantage, usually involving non-payment for overtime, comp time, vacation leave, personal leave, sick leave, military leave, and so forth. The remedy for correcting these pay discrepancies was to file a grievance, resulting in my supervisors accusing me of filing frivolous grievances, quote unquote. As a result of my grievances, the typical official explanation given to me would be that payroll had not received my paperwork, which somehow had been lost between the captain's office and payroll, and I would get paid several weeks later upon my resubmission of the paperwork. I had injured my back during active duty Army training in 1988, resulting in 3 herniated discs, and if I wasn't careful, I would aggravate my back from time to time. In April of 1990, just prior to a weekend drill with my reserve unit, I aggravated my back. So instead of attending drill, I reported to the hospital and was seen by a doctor and received work excuses for both my reserve unit and my employer. 6 months later, I was arrested at my home pursuant to a sub rosa secret grand jury indictment for the 3rd-degree felony charge of theft in office. I was accused of requesting paid military leave and then not attending drill and accepting the pay, when I actually submitted a request for leave changing my military leave previously requested to sick leave with an accompanying doctor's excuse, and I had witnesses. Remember how I mentioned how my paychecks were always messed up and how they would claim that payroll had not received the paperwork? As a result of this, I began the personal practice of making a Xerox copy of any and all paperwork submitted to my supervisors during roll call, and having different witnesses sign my copies, verifying that they witnessed me submit the original. On this particular occasion, the person who I thought was a friend and requested to witness my submitting my sick leave request and doctor's excuse went off on me, asserting that my pulling asinine shit like that was why management hated me, and deservedly so. I tried to explain to him that I just wanted to get paid like everyone else, and if they didn't mess with my pay, he would never hear from me about it again. In any event, Thinking that he was making a fool out of me, while I submitted the original, my witness had his cronies who were sitting with him, and who he was no doubt trying to impress, sign my copy. Little did I know at the time how fortunate I would be 6 months later to have 5 hostile witnesses on my side. My indictment was on the front page of the local newspaper and announced every hour on the hour over the local radio stations. Those who know me know that I'm a frugal person, and since it was such a simple case, I hoped to get it dismissed without the expense of hiring a criminal attorney. So shortly after my arrest, but before my arraignment, my friend, the late State Representative Frank Sawyer, my friend, the late then-retired Mansfield attorney E.A. White, and my friend and fellow union representative Bob attended a meeting with Prosecutor Mayer on my behalf. Mr. White advised me to not attend the meeting, which my eventual attorney agreed was sound advice. At the meeting, they gave copies of evidence that I had secured in preparation for my pre-disciplinary conference based on the accusation that I had been indicted. The exculpatory evidence given to Prosecutor Mayer included my original request for military leave, my amended request for sick leave signed by 5 hostile witnesses, my doctor's excuse, a printout from the drugstore for the pain medication the emergency room doctor had prescribed to me, my canceled check to the drugstore, and affidavits from the emergency room doctor and the pharmacist who filled my prescription. Prosecutor Mayer assured my friends that it was not his intent to prosecute an innocent man, and that he would check out the evidence they had just given him, and if it checked out, he would drop the charges against me and issue a public apology. Sadly, Mr. Mayer was not a man of his word, as I learned the next day. Those who know me know that I'm known for not leaving a stone unturned. As a cherry on top of the proverbial sundae, I wanted to get a copy of the payroll's copy of my amended sick leave request and doctor's excuse bearing their timestamp. So the next day, I reported to the personnel office and requested the copy. Not realizing the significance of what she was about to do, the payroll clerk, in my presence, asked the investigator from the Richland County Prosecutor's office, who just happened to be at the personnel office and digging through my file for more dirt on me, for my file, which she had just given him, so that she could make a copy of something for me. As it turned out, it was not there, because it had undoubtedly gotten lost on its way from the captain's office. It was a good thing that I had implemented my personal practice of getting witnesses to witness my submission of paperwork to my lineup supervisors. And incidentally, after my ordeal was eventually over, it was due to my so-called frivolous grievance that a timestamper was purchased for lineup, a practice which continues to this day. This is a photograph of my wife and twin daughters around the time of my malicious and wrongful prosecution as a political favor to my employer by Prosecutor Mayer. I'm including it because not only was this a stressful time for me, it was a stressful time for them as well. My supportive homemaker wife secretly worried about what she would do if I were to be fired, let alone convicted and sent to prison. Some not-so-supportive family members made it very clear to her that people just don't get indicted for nothing, and that she would have to get a job and a cheaper place to live because she and the kids were not welcome to move in with them when, not if, I went to prison. And my young daughters got to watch their dad get arrested and handcuffed and placed into the back of a police car. Due to Prosecutor Mayer not making good on his word, my case drug out for 6 long and stressful months, and it would probably still be going on today, 32 years later, had I not rejected my attorney's advice to waive my right to a speedy trial and to accept the many plea deals, which all included my having to plead no contest for something I didn't do, which would have resulted in a conviction, which would have guaranteed my removal. And not only was it stressful, it was expensive. As a result of my having to obtain an attorney, we had to deplete our savings, which we were saving for a down payment on a house, and no, I was never reimbursed a single penny. After 6.5 stressful months, and my refusal to waive my constitutional right to a speedy trial, as well as my rejection of the many plea deals offered to me, including the reduction of the third-degree felony down to a minor misdemeanor, with a $1 fine and waiving the fine, the extremely anti-union Richland County Common Pleas Court Judge James Henson reluctantly dismissed the charges against me, as there was no way Prosecutor Mayer and his team would ever be prepared to bring a case against me to trial. Viewers may find it as funny as I did that the same local newspaper that deemed my indictment newsworthy enough to appear on their front page the day of my indictment and arrest did not find the dismissal of the charges against me newsworthy enough to even print an article about it until I submitted a letter to the editor criticizing them a month after the charges had been dismissed. About 25 years later, after receiving documents pursuant to a public records request, I learned that after the Richland County Common Pleas Court dismissed a third-degree felony charge of theft in office, Prosecutor Mayer's office unsuccessfully tried to charge me with misdemeanor theft. I'm not an attorney, but this sounds a lot like unconstitutional double jeopardy to me. The Mansfield Municipal Court made the right call in rejecting their request. In 1992, 2 years after my ordeal with Prosecutor Mayer's office, a criminal suspect with alleged mental health issues confessed and was subsequently convicted of murder. He didn't just confess to the crime, he signed 5 coerced confessions, including at least one which asserted that he murdered the victim for having fired him when he never worked for the victim. Prosecutor Mayer's lead investigator, who secured these confessions through bribery and coercion, was the lead investigator in the criminal case against me. He never read Mr. Tinney his Miranda rights, including his right to counsel. He was able to get Mr. Tinney to sign the confessions by promising cigarettes and assistance in getting money that belonged to him from the Mansfield Police Department. The Ohio Innocence Project took an interest in Mr. Tinney's case, and in 2012, hearings were conducted by Richland County Common Pleas Court Judge James DeWeese. During 7 days of hearings, 3 police officers who had worked on Mr. Tinney's case for many years testified that the evidence indicated that Mr. Tinney was actually innocent. After hearing all the evidence, Judge DeWeese, in a scathing judgment entry, reversed the murder conviction of Mr. Tinney, who had already served over 20 years in prison, and granted him a new trial. The prosecutor's office declined to prosecute Mr. Tinney any further. In 2014, lawyers from the state of Indiana filed a lawsuit alleging that Prosecutor Mayer and his lead investigator had violated Mr. Tinney's civil rights. That lawsuit stated that Prosecutor Mayer's office had a de facto policy of pursuing wrongful convictions through profoundly flawed investigations and coerced evidence. Speaking of evidence, at least one piece of evidence that had been used to secure the indictment against me had been criminally falsified in violation of the Ohio Revised Code. It was a Department of Defense form used to document unit drill attendance. I know that it was criminally falsified because I'm the one who typed the form. Due to my previously discussed back injury, I had been involuntarily temporarily reassigned as unit clerk with my reserve unit. It was actually a good fit for me because I've always been a paperwork geek. In any event, the document in question listed the names of all members of our unit, and next to each name I typed a P for present, or E for excused, or U for unexcused. I had typed an E next to my name since I had submitted a doctor's excuse for my absence. Someone using a felt tip pen criminally falsified this public record by putting a slash through the E and writing a U. In addition to being criminal, this was against Army protocol and regulations, as we were not allowed to use whiteout or correction tape or make handwritten changes to the document. In the event we made a mistake, we were required to retype the entire page on which the mistake had occurred. I do not claim to be a handwriting expert, but I did find it compelling that the U written by the person who criminally falsified this piece of evidence looked identical to U's made by Prosecutor Mayer's lead investigator, who also wrote exclusively with felt tip pens. I had the occasion to receive numerous handwriting samples by this individual because he later accepted a job as investigator at the Mansfield Correctional Institution, where I worked, and he unsuccessfully wrote me up numerous times, including incidents at the institution that occurred only in his mind on my days off when I was nowhere near the prison, and at least one occasion allegedly occurring at the exact same date and time at other parts of the institution for which other supervisors had also unsuccessfully written me up. Not long after the filing of Mr. Tinney's bombshell lawsuit, Mr. Mayer committed suicide at his home. I have no idea whether or not Mr. Mayer had a last-second come-to-Jesus moment. I just know that he never apologized to me, privately or publicly, for the harm and stress he caused my family and me, and that, as a Christian, I forgave him back in 1991. I sincerely hope that he is in peace. With respect to why Mr. Mayer killed himself, his and my priest at the time, the late Father Gregory Height, aptly put it in his homily during Mr. Mayer's funeral mass. He said, "We may never know the whole story, have all the answers."